Okay, so we're going to be talking about the hearsay rule and a lot of its exceptions today. So at least in the state of Georgia, this is going to get a little in depth and all that. So here's what we're going to do. At some point during this video, we're going to have a code word, and we're going to say code word at some random point in the video, and then what that word is. And what we're going to do, the first 3 people that stick it out through where we say code word, and if you email me at Joel, Joel, at gatrialattorney.com, tell me the timestamp where we say the code word and what the code word is, then give me your mailing address. We will send you an envelope with a $50 bill in it, and it's all yours just for enduring this video. Hey everyone, welcome back to the Williams Elleby YouTube channel. I'm Joel, this is Chase. We're trial lawyers here in the state of Georgia, and today we've got a fascinating topic to dive into, the hearsay rule and its exceptions. If you've ever wondered what hearsay is and why it matters in the legal world, you're in the right place. Chase is especially excited about this. Most lawyers have paid a lot of money to learn these things in law school, and we're going to hit the highlights here for free. You're welcome. But before we get started, be sure and hit that subscribe button, hit that notification bell so you never miss out on our legal insights and updates.
All right, so what exactly is hearsay? Well, in a nutshell, hearsay is an out-of-court statement that's offered for the truth of the matter asserted. So in other words, it's when someone tries to prove a fact by offering a statement that someone else made out of court.
Yeah, but let's get a little more technical here. According to the hearsay rule, which is a fundamental principle of the law of evidence, hearsay statements are generally not admissible in court. The rule is designed to ensure that only reliable and first-hand evidence is presented at trial.
All right, so let's consider an example. Imagine a witness, John, says in court, "Sarah told me that the defendant stole the laptop." This is hearsay because John is repeating something someone else said, and he's saying it to prove that that's actually what happened, that the defendant or whoever the person was stole the laptop.
Right. And the hearsay rule is crucial because it helps maintain the integrity of the legal system. It ensures that information presented in court is subject to cross-examination by other attorneys, and that it can be tested for accuracy and reliability. Now, in Georgia, the hearsay rule and its exceptions are codified at OCGA 24.8.801 through 807.
All right, so now that we covered the basics of the hearsay rule, let's explore some of the common exceptions that allow hearsay evidence to be admitted into court. So some exceptions only apply when the person who made the out-of-court statement is unavailable as a witness. Other exceptions apply regardless of whether the declarant, the person making the statement, is available in court as a witness.
Yeah, so first let's go over the exceptions that apply regardless of whether the person who made the out-of-court statement is available to testify under oath and in court. So the first exception is called a present sense impression. A court should not exclude a statement describing or explaining an event or condition made while the declarant was perceiving the event or condition or immediately thereafter. So, for example, if a store manager sees someone fall in a puddle of water and immediately exclaims, "Oh my goodness, you fell when you stepped in that puddle of water," that statement can be introduced into evidence by a witness who heard the store manager make the statement.
So the next exception is what we call an excited utterance. That is a statement relating to a startling event or condition made while the declarant was under the stress or excitement caused by the event or condition. All right, so imagine a witness, Mary. She's walking down the street when suddenly she witnesses a car accident. She's standing close to the scene, and immediately after the crash, she exclaims, "Oh my goodness, that was so scary. Blue car ran the red light and slammed into the gray SUV." Well, that statement is an excited utterance. So in that scenario, Mary's statement qualifies as an excited utterance exception to the hearsay rule because it was made spontaneously without the opportunity for reflection and was influenced by the shock and the emotion, or the emotional intensity rather, of witnessing that accident. So courts often consider such statements to be reliable because they're less likely to be fabricated or distorted due to the immediacy of the event. So think about Mary's statement and how it was said immediately. So the statement may be admitted in court as an exception to the hearsay rule to describe what she observed during that accident.
Right. Okay, so the next exception is then existing mental, emotional, or physical condition. So that means a statement of the declarant's then existing state of mind, emotion, sensation, or physical condition, such as intent, plan, motive, design, mental feeling, pain, and bodily health. So let's say that Sarah was involved in a car accident with another driver. We'll call him Alex. Following the accident, Sarah is taken to the hospital for treatment. While she's in the hospital, a nurse asks her, "How did this accident happen?" And in response, Sarah says, "I'm in so much pain. Alex ran a red light and crashed into my car." In this case, Sarah's statement about her pain and the description of the accident may fall under the existing mental, emotional, or physical condition exception to the hearsay rule. The statement explains Sarah's physical condition or her pain at the time that she made the statement, and it's relevant to her medical treatment as it helps medical professionals assess her injuries and provide appropriate care. So therefore, Sarah's statement may be admitted as an exception to the hearsay rule because it pertains to her existing physical condition at the time she made the statement.
So the next exception are statements for the purposes of medical diagnosis or treatment. So the Georgia Code section says is that statements for the purpose of medical diagnosis or treatment and describing a medical history or past or present symptoms, pains, or sensations, or the inception of general character of the cause or external source thereof, insofar as reasonably pertinent to diagnose or to diagnosis or treatment. That's a mouthful.
Give me an example.
Thank you. All right. So let's say Sarah's experiencing severe stomach pain, goes to the doctor and tells Dr. Smith, "Hey, my stomach's hurting." So during the examination, Dr. Smith's going to say or ask Sarah, "Tell me, have you ever had any unusual dietary habits or foods or allergies or anything like that?" And in Sarah's response, she might say something like, "Yeah, I've been eating a lot of spicy food lately. I think that's what's causing my stomach a lot of pain." Okay. In this scenario, Sarah's statement about her dietary habits and her belief that the spicy food may be causing her stomach pain may fall under the exception to the hearsay rule for medical diagnosis or treatment. So the doctor, in asking her these questions, are not for the legal proceedings or legal purposes. It's only to diagnose Sarah for the treatment that she's experiencing, it's only to diagnose Sarah for the condition that she's experiencing so that he can provide effective treatment.
Yep. And it's relevant to her medical care because it helps the doctor understand the potential cause of her ailment.
That's exactly
So therefore, the statement can be admitted as an exception to the hearsay rule because it was made for the purposes of medical diagnosis or treatment.
That's right.
All right. Exception number 5 is a recorded recollection. And Georgia law says that a recorded recollection is a memorandum or record concerning a matter about which a witness once had knowledge but now has insufficient recollection to enable the witness to testify fully and accurately as shown to have been made or adopted by the witness when the matter was fresh in the witness's memory and to reflect that knowledge correctly. So if admitted, the memorandum or the record may be read into evidence, but it cannot be received as an exhibit unless offered by an adverse party. That's another mouthful. So, example, imagine Sarah is a witness in a trial concerning a car accident that occurred over a year ago. She was asked to testify about the details of the accident in court, but she's having difficulty recalling specific details accurately. Sarah made a detailed written statement about the accident shortly after it happened when her memory was fresh. So during her testimony, Sarah can be shown the written statement, and if she confirms that it's a document she created at or near the time of the accident, and she still cannot remember all the details of the accident vividly from her own independent recollection, then the recorded recollection or the writing can be applied. That exception can be applied. So her attorney can ask her to read her written statement into evidence to refresh her memory and provide a more accurate account of the events. Now, the document itself becomes evidence, and Sarah can read from it while testifying, even though it's technically hearsay because it's an out-of-court statement offered to prove the truth of the matter asserted. This exception allows the court to rely on contemporaneously written recorded statements to ensure the accuracy of testimony when the witness's memory is impaired.
Right. All right, so the next exception, and there's a lot of them, so you have to bear with us, are records of regularly conducted activity. And the code section says, unless the source of information or the method or circumstances of preparation indicate lack of trustworthiness and subject to other expert witness requirements, a memorandum, report, record, or data compilation in any form of acts, events, conditions, opinions, or diagnosis, if A, made at or near the time of the described acts, events, conditions, opinions, or diagnosis, B, made by or from information transmitted by a person with personal knowledge and a business duty to report. C, kept in the course of a regularly conducted business activity. And D, it was the regular practice of that business activity to make the memorandum, report, record, or data compilation, all as shown by the testimony of the custodian or other qualified witness, or by certification that complies with paragraph 11 or 12 of Code Section 24-9-902, or by any other statute permitting certification. The term business, as used in this paragraph, includes any business, institution, association, profession, occupation, and calling of every kind, whether or not conducted for profit. And congratulations if you're still listening to this video, because this is some meaty stuff. All right, so suppose a legal dispute arises regarding a personal injury claim stemming from an incident at a retail store. The store's manager, John, is called as a witness to testify about the safety procedures followed by the store. So during his testimony, John refers to the store's incident log, which documents all the accidents and incidents that have occurred on the premises. So John explains that if it is the standard practice at the store to record all accidents in the incident log as soon as they happen, including details such as the date, the time, the location, and a brief description of what occurred. John did not personally witness the incident in question, but he relies on the incident log to provide accurate information about what had happened. So in this scenario, the incident log may be admitted as evidence under the record of regularly conducted activity exception. The log was created in the ordinary course of the store's business to maintain a record of safety incidences and is regularly kept up to date. So as long as certain foundational requirements are met, such as establishing the reliability of the record-keeping process, and this is usually done in direct examination, the incident log can be used as evidence, even though it contains statements made by individuals who are not testifying in court. And so this exception helps ensure that the reliability of the record is kept in the normal course of business.
Now that we're all thoroughly bored, let's go to the next one, which is the opposite of what Chase talked about, and that's the absence of entry in records kept in accordance with that paragraph of this particular code section. Now, Georgia law says that evidence that a matter is not included in the memoranda, reports, records, or data compilations in any form kept in accordance with the provisions of paragraph 6, which is what Chase just read of this code section, to prove the non-occurrence or non-existence of the matter if the matter was of a kind of which a memorandum, report, record, or data compilation was regularly made and preserved, unless the sources of information or other circumstances indicate a lack of trustworthiness. So here's an example. Suppose a company, we'll call it XYZ Corporation, is facing a lawsuit from a former employee, we'll call her Alice, who claims that she was wrongfully terminated. As a part of her case, Alice alleges that she reported the wrongful termination to the company's HR department and they failed to address her complaint. Now, during the trial, the company's HR manager, we'll call her Sarah, is called to testify. Sarah maintains records of all employee complaints and investigations, and she testifies that she has searched the HR department's records for any complaint or report from Alice regarding her alleged wrongful termination, but found none. In this particular scenario, Sarah's testimony about the absence of an entry in the records can be admitted as an exception to the hearsay rule. The absence of a record can be relevant to the case because it suggests that no complaint was received or recorded by the HR department, which contradicts Alice's claim. Now, Sarah's testimony is not considered hearsay because she's not relying on a specific statement made by Alice, but is instead testifying about the absence of an entry in the business records, which can be used to rebut Alice's assertion.
Right, so it's like, well, how do you know? Well, I know because I always keep records of these complaints and we didn't have one complaint at all. So that's kind of the basic one. All right, so the next exception is public records and reports. The code section says public records, reports, statements, or data compilations in any form of public offices setting forth the activities of the public office, matters observed pursuant to duty imposed by law, as to which matters there was a duty to report, excluding, however, against the accused in criminal proceedings, matters observed by police officers and other law enforcement personnel in connection with an investigation, or in civil proceedings and against the state in criminal proceedings, factual findings resulting from an investigation made pursuant to authority granted by law, unless the sources of information or other circumstances indicate lack of trustworthiness. Welcome back. All right, so let's suppose your criminal trial is underway and the prosecution is trying to prove that the defendant, we'll call him John, has a prior criminal conviction for a similar offense. All right, so to establish this, the prosecution has to introduce a certified copy of John's criminal record obtained from the state's Department of Corrections. So in this scenario, the certified copy of the criminal record is a public record and report. It was created and maintained by a government agency in the regular course and activities of that job, and it contains information about John's prior criminal convictions. So this record can be admitted as an exception to the hearsay rule because it falls under the category of public records and reports. So the thing to remember that the key elements of this exception are that the records must be created by a government agency or office, and it must be made and kept in the regular course of business, and it must be certified or authenticated to ensure its accuracy. In this case, the certified copy of John's criminal record meets these criteria and can be used as evidence against him in court.
All right, if you're still with us, comment below because I'm impressed. All right, the ninth exception is record of vital statistics, and the Georgia Code section says, records or data compilations in any form of births, fetal deaths, or marriages, if the report thereof was made to a public office pursuant to the requirements of law. All right, so imagine a divorce case in which one of the issues in dispute are the dates of the marriage of the couple. So one spouse, we'll go back to Sarah, claims that they were married on a specific date, while the other spouse, John, disputes this and argues that they were married on a different date. To resolve the issue, Sarah's attorney can present a certified copy of their marriage certificate issued by the relevant government agencies, such as the Department of Health or Vital Statistics. Now, the marriage certificate includes the names of the parties involved and the dates of the marriage. In this scenario, the certified copy of the marriage certificate is a record of vital statistics. It was created and maintained by an official government agency that is responsible for recording and preserving such vital events as marriages. And because it's an official record that falls under the category of vital statistics, it can be admitted as an exception to the hearsay rule. The document's reliability and authenticity are typically ensured through the certification, making it a reliable source of information regarding the date of the marriage in question.
Exception 10 is the absence of a public record or entry. So the code section says, to prove the absence of a record, report, statement, or data compilation in any form, or the non-occurrence or non-existence of a matter of which a record, report, statement, or data compilation in any form was regularly made and preserved by a public office, evidence in the form of a certification in accordance with section or code section 24.9.902, or testimony that diligent search failed to disclose the record, report, statement, or compilation or entry. All right, so let's imagine a legal dispute over the ownership of a piece of real estate. So party A claims to be the rightful owner of a property and argues that there are no recorded liens or encumbrances or anything like that on the property. Well, party B disputes this and believes that there is a recorded lien on the property. So during the trial, party A lawyer presents a certificate from the county clerk's office stating that there are no recorded liens or encumbrances on the property in question. In this scenario, the certificate from the county clerk's office is an example of a record of the absence of a public record or entry. It is a statement from an official source indicating that according to the public records maintained by the county clerk, there are no recorded liens on the property. This certificate can be admitted as an exception to the hearsay rule to demonstrate, as far as the public records are concerned, that there are no encumbrances on that property. So this exception allows the parties to provide evidence that a particular public record or entry does not exist, which can be relevant to the case.
Okay, here we go. Number 11, records of religious organizations. So the Georgia Code section says that statements of birth, marriages, divorces, deaths, legitimacy, ancestry, relationship by blood or marriage, or other similar facts of personal or family history contained in a regularly kept record of a religious organization is a hearsay exception. So Let's imagine a case where a couple, John and Mary, who are members of a certain church, are disputing the terms of their marriage and its dissolution. They are seeking a divorce, and the issue at hand is whether their marriage was formally recognized and recorded by the church. So during the trial, let's imagine that John presents a certified copy of the church's marriage register, which includes the details of the marriage ceremony, the officiating minister's signature, and the date of the marriage. This marriage register is maintained by the church or the religious organization as part of its regular record keeping. In this scenario, the certified copy of the church's marriage register is an example of the records of religious organizations, which are exception to the hearsay rule. It's a document that's created and maintained by the religious organization in the regular course of its activities, specifically for recording and documenting religious events like marriages. So the exception allows such records to be admitted as evidence to establish the validity or the existence of a religious event. In this case, the marriage, even though it contains out-of-court statements like the minister's certification of the marriage. The key factor here, though, is that the record is kept by the religious organization in accordance with its practices and procedures.
All right, so sticking with marriages and religion, we'll go to exception number 12, and this is marriage, baptismal, and similar certificates. So the code section says, statements of fact contained in the certificate that the maker performed a marriage or other ceremony or administered a sacrament made by clergyman, public official, or other person authorized by the rules or practices of a religious organization or by law to perform the act certified and purporting to have been issued at the time of the act or within a reasonable time thereafter. All right, so imagine a situation where a couple, go back to Sarah and John, they're the best, is seeking to prove the validity of their marriage in a legal proceeding. They want to demonstrate that they are legally married to each other. So to support their claim, Sarah and John present a certificate of marriage completed by a priest. The marriage certificate contains the details such as their names, the date and the place of their marriage, and the officiating authority, and witnesses' signatures. In this scenario, the certified copy of the marriage certificate is an example of the marriage, baptismal, and similar certificates exception to the hearsay rule. The certificate is an official document issued by a priest to confirm the occurrence of a marriage. It's considered a reliable record of the marriage event and is admissible as evidence to establish the fact that Sarah and John did have a legal marriage and binding marriage between them.
Yeah, and even though it contains statements made by individuals that are not there to testify in court.
That's exactly right.
So that's why it's the exception to the hearsay rule. All right, number 13 exception, family records.
Lucky 13.
Yeah, Georgia law says that statements of fact concerning personal or family history contained in family Bibles, genealogies, charts, engravings on rings, inscriptions on family portraits, engravings on urns, crypts, or tombstones, or the like are an exception. So, let's imagine a legal dispute over the rightful ownership of a family heirloom, a valuable antique painting that's been passed down for generations. Let's go back to our plaintiff Sarah, who claims that the painting rightfully belongs to her family and presents a family record as evidence. Now, this family record is a family Bible that has been in her family for over a century. And inside the Bible, Grandma Judy made a handwritten note that states the painting, Sunset Over the River, belongs to our family and is to be passed down to future generations. Why this is in the Bible, I don't know, but it is. But in this scenario, the family Bible and the handwritten entry by Sarah's grandmother are examples of family records exceptions to the hearsay rule. So the entry in the family Bible is considered to be a reliable record of family history and is being offered to prove the family's ownership of the painting, a matter of importance in this particular legal dispute. Now, while the statement in the Bible is technically hearsay, because the grandmother is not there and it's an out-of-court statement, it falls under the family records exception because it's a record created within the family setting, kept over time, and is regarded as trustworthy, at least under the eyes of the law, for matters of family history, including property ownership and inheritance. So the key to this exception is that the record must be a traditional family document like a family Bible, diary, or similar record, and it must be offered to prove a relevant fact about the family's history.
Yeah, and if you've stuck with us this long, you'll notice that a lot of the themes of these exceptions are trustworthiness, right? So the law really tries to emphasize whether or not the source of any information, if it's made by someone outside of court, is trustworthy. All right, so exception number 14 are records of documents affecting an interest in property. So the code section here says, the record of a document purporting to establish or affect an interest in property as proof of the content of the original recorded document and its execution and delivery by each person by whom it purports to have been executed, if the record is a record of a public office and an applicable law authorizes the recording of documents or that kind in such office. All right, so a real quick and easy example of this exception is, let's say that Joel and I are arguing over a piece of property. Well, I could go down to the clerk's office and get a certified copy of the property deed that shows me, Chase Elleby, owns a specific piece of property. And even though there's statements in that deed that are out-of-court statements, because it's going to be certified and because it's from the clerk's office, I will be able to use that piece of evidence or that document to prove an out-of-court statement to show that I am, in fact, the rightful owner of that piece of property.
All right, exception number 15 is statements and documents affecting an interest in property. So Georgia law says that this exception is defined as a statement contained in a document purporting to establish or affect an interest in property if the matter stated was relevant to the purpose of the document, unless dealings with the property since the document was made have been inconsistent with the truth of the statement or the purport of the document. All right, that almost makes no sense, but here's an example. Imagine a real estate transaction where party A is purchasing a commercial property from party B. As part of the transaction, they enter into a written contract for the sale of the property. Now, the contract contains various terms and conditions, including the purchase price, the closing date, and a provision that party B will vacate the property by a specific date. After the closing date has passed, party A finds that party B has not vacated the property as agreed upon in the contract. Party A initiates legal proceedings to evict party B from the property. During the eviction trial, party A's attorney introduces the written sales contract into evidence. The contract contains a provision in which party B explicitly agrees to vacate the property by a specific date. This provision contradicts party B's claim that they had a right to remain on the property. So in this scenario, the statement made by party B and the written sales contract that agrees to vacate the property by a specific date falls under statements and documents affecting an interest in property exception to the hearsay rule. Although party B's statement is technically hearsay or an out-of-court statement offered for its truth, it is admitted as evidence because it's contained, I don't even know what's funny about this, but it's contained within a document that directly affects the party's property interest. The statement in the contract helps establish party B's obligation to vacate the property according to the terms of the agreement. And this exception allows parties to rely on statements made in property-related documents, such as contracts, leases, and deeds, to prove their claims or defenses in property disputes, even if the statements would have otherwise be considered hearsay.
It's funny because all the hearsay exceptions are just, it's comical.
Yeah, it's so funny and entertaining.
All right, so exception 16 are statements and ancient documents. And these are statements and documents in existence 20 years or more, the authenticity of which is established, right? So you have to establish that the documents are 20 years or older. All right, so let's imagine a legal dispute over the boundary lines of a piece of land. Party A claims that the boundary lines extend further into the neighboring property, while Party B disputes this and argues that the boundary line is where it currently stands. So during trial, Party A's attorney presents an old land survey report that was conducted by a reputable land surveyor 100 years ago. So this report includes a detailed description of the property boundaries, complete with measurements, markers, and a description of nearby landmarks, okay? So even though the report contains statements from the land surveyor that are technically hearsay, as they're made, statements that are made out of court, the age and reliability of the document make it an exception to the hearsay rule. The report is considered trustworthy, again, that's the buzzword you hear a lot, because it was created at a time when the boundaries were likely to be accurately described and was conducted by a reputable professional. So this exception allows parties in property-related disputes to introduce old documents such as land surveys, maps, or other historical records as evidence of historical property facts, even if the statements for those documents would typically be classified as hearsay.
All right, anybody that was thinking about law school is easily backing out right now, and they're going to be completely out the door after number 17, which is market reports and commercial publications. So Georgia law says market quotations, tabulations, lists, directories, or other published compilations generally used and relied upon by the public or by persons in the witness's particular occupation are not hearsay, or they're an exception. So imagine a lawsuit in which Company A is suing Company B for breach of contract related to the sale of a specific commodity, let's just say wheat. Company A claims that Company B did not deliver the agreed upon quality of wheat at the agreed upon price that resulted in financial losses. During the trial, Company A's attorney introduces a published industry report from a reputable agricultural organization. I'm not even going to make up a name for that, but this report contains data and analysis of wheat prices, supply, and demand trends in the market during the relevant time period. So the report includes a statement that wheat prices surged by 20% during the quarter in question due to a sudden decrease in supply. In this scenario, the statement that's within the published market report may fall under the market reports and commercial publications exception to the hearsay rule. Although the statement is an out-of-court statement and typically hearsay, it is admissible because it's contained within a reputable and widely recognized commercial publication that reports on market conditions. So these type of publications are considered reliable sources of information regarding market trends, and statements within them are often admitted as evidence in commercial and business-related cases.
All right, so what comes after 17? 18. Exception 18 are learned treatises. All right, so the code section says, to the extent called to the attention of an expert witness upon cross-examination, statements contained in published treatises, periodicals, or pamphlets, whether published electronically or in print, on a subject of history, medicine, or other science or art, established as a reliable authority by the testimony or admission of the witness, by other expert testimony, or by judicial notice. If admitted, the statements may be used for cross-examination of an expert witness and read into evidence, but shall not be received as exhibits. All right, so let's imagine a medical malpractice lawsuit in which the plaintiff claims that a surgeon's alleged negligence during a procedure caused them harm. So to support their case, the plaintiff's attorney presents an excerpt from a widely recognized and authoritative medical textbook that discusses the correct surgical procedure for the specific type of surgery in question. The excerpt from the medical textbook contains a statement that outlines the proper surgical technique and precautions that should have been taken during the procedure. It also highlights the potential risks and the complications associated with the surgery when not performed according to the accepted standards of care. So in this scenario, the statement from the authoritative medical textbook may fall under the learned treatises exception to the hearsay rule. Even though it's an out-of-court statement and would typically be considered hearsay, an expert can still be cross-examined using the material because it is derived from a reputable and widely recognized source within the medical field. Again, it's that trustworthiness. So scholarly works, textbooks, and treatises authored by experts in the field are often considered authoritative, and statements from these sources can be introduced in court to establish the acceptable standards of care or the standards of practices to support the expert's testimony.
All right, exception number 19 is reputation concerning personal or family history. So the Georgia Code section says, reputation among members of a person's family by blood, adoption, or marriage, or among a person's associates, or in the community concerning a person's birth, adoption, marriage, divorce, death, legitimacy, relationship by blood, adoption or marriage, ancestry, or other similar fact of the person's personal or family history. All right, example time. So let's imagine a scenario where there is a life insurance coverage dispute concerning whether a child has been adopted into a family. So the child dies and there's a dispute. In this scenario, the family member that is attempting to collect on the life insurance proceeds may call a different family member to testify that they have adopted several children throughout the years, and that after every adoption is completed, the family would have had a gathering to celebrate the adoption of the new family member. Now, the family member that's called to testify may testify that the family had just such a gathering to celebrate the adoption of the now deceased adopted child, and that's an exception.
All right, exception number 20 is reputation concerning boundaries or general history. The code section says, reputation in a community arising before the controversy as to boundaries of or customs affecting lands in the community, and reputation as to events of general history important to the community or state or nation in which such lands are located. All right, so let's imagine another property dispute between two neighboring landowners. We'll go with Alice and Bob this time because why not, right? So Alice and Bob, they're having a dispute concerning the exact location of their property boundary. Alice claims that the boundary is marked by a specific tree located on her side of the property, while Bob, on the other hand, insists that the boundary is further into Alice's land. During trial, Alice's attorney called several longtime residents of the neighborhood to testify about the community's reputation and understanding of the property boundary. So these witnesses have lived in the area for decades and have witnessed various property transactions and boundary disputes over the years. So the witnesses then testify that according to the collective understanding within the community that the property boundary has and always will be recognized as extending up to the specific tree on Alice's side of the property. So they describe how this understanding has been passed down through generations and has never been, seriously contested until Bob comes along and says, well, no, it's not that tree. So in this scenario, the testimony from the longtime residents about the community's reputation and historical understanding of the property boundary falls under this exception.
All right, exception number 21 is reputation as to character. So reputation of a person's character among associates or in the community is an exception. So you can imagine a criminal trial in which the defendant, we're going to go back with Sarah, is charged with embezzlement. The prosecution alleges that Sarah misappropriated funds from her employer's company. So one of the key issues in the trial is whether Sarah has a reputation for honesty and trustworthiness within her community. During the trial, her defense attorney called several colleagues and acquaintances of Sarah to testify about her reputation for honesty and trustworthiness. These witnesses have known Sarah for years and worked closely with her. They describe Sarah as a person who's known for her integrity or honesty and her ethical conduct in her personal and professional life. Now, in this scenario, the testimony from Sarah's colleagues and acquaintances about her reputation for honesty and trustworthiness, what are you laughing at? falls under the reputation as to character exception to the hearsay rule. Now, these witnesses are not providing specific incidents or statements, but are conveying a collective understanding within the community regarding Sarah's character traits.
All right, so now we're at exception number 22, and it's time for the code word. Code word's fire alarm. All right, so exception number 22 is a judgment of a previous conviction. Exception number 22 says, evidence of a final judgment entered after a trial or upon a plea of guilty, but not upon a plea of nolo contendere, adjudging a person guilty of a crime punishable by death or imprisonment in excess of 1 year to prove any fact essential to sustain the judgment, but not including when offered by the state in a criminal prosecution for purposes other than impeachment. Judgments against persons other than the accused. All right, so let's imagine we're in a trial in which the defendant, John, is charged with a new crime, armed robbery. The prosecution seeks to introduce evidence of John's previous conviction for armed robbery, which occurred 5 years ago. So during this trial, what the prosecution will do is they'll get a certified copy of that prior conviction, and they'll be able to admit that into evidence to prove that that crime did in fact occur 5 years prior. So as long as it's a certified copy that he pled guilty to that crime and it's a felony, the prosecution is able to use that and it's not considered hearsay.
All right, finally, exception number 23, judgment as to personal, family, or general history or boundaries. Judgments as proof of matters of personal, family, or general history or boundaries essential to the judgment if the same would be provable by evidence of reputation. I don't know what that means. I can't find a case that applies this rule at all. So if you want to know the answer to what this means or an example, call a law professor, because I'm not smart enough.
Yeah, we're not law professors.
Yeah. So there are 5 other exceptions to the hearsay rule, and these exceptions require that the declarant, or the person who supposedly said the statement, is unavailable for trial. So Georgia law says that a witness is unavailable if, number 1, they are exempted by ruling of the court on the ground of privilege from testifying concerning the subject matter of the declarant's statement, or 2, they persist in refusing to testify concerning the subject matter of the declarant's statement despite an order of the court to do so, or 3, they testify to a lack of memory of the subject matter of the declarant's statement, or 4, they're unable to be present or to testify at the hearing because of death or then existing mental illness, physical illness, or infirmity, or if they are absent from the hearing and the proponent of the statement has been unable to procure the declarant's attendance, or in the case of exceptions under other paragraphs of subsection B of this code section, the declarant's attendance or testimony by process or other reasonable means. A declarant shall not be deemed unavailable as a witness if the declarant's exemption, refusal, claim, lack of memory, inability, or absence is due to the procurement or wrongdoing of the proponent of a statement for the purpose of preventing the witness from attending or testifying. All right, the first exception that requires the declarant not to be available is this. And this is what Georgia law says, is the following shall not be excluded by the hearsay rule, even if the declarant is unavailable as a witness. Testimony given as a witness at another hearing of the same or a different proceeding, or in a deposition taken in compliance with law in the course of the same or another proceeding, if the party against whom the testimony is now offered, or in a civil proceeding, a predecessor in interest, had an opportunity in similar motive to develop the testimony by direct, cross, or redirect examination. All right, let's go back to our example. So imagine a personal injury lawsuit in which the plaintiff, we'll call her Jane, is suing the defendant, a construction company, for injuries that she sustained when scaffolding collapsed at a construction site. So during the discovery phase of the lawsuit, Jane provides a deposition under oath in which she describes the detail of the accident, the injuries that she suffered, and her version of the events. Now, before the trial, Jane unexpectedly becomes ill and is unable to attend the trial or testify in person. So her deposition testimony, which was conducted under proper legal procedures and allowed the defendant to cross-examine her, or the defendant's attorney to cross-examine her, is available. In this scenario, Jane's prior deposition testimony can be offered as an exception to the hearsay rule in the civil case. So the key elements for this exception to apply are unavailability of the witness. Jane is unable to attend the trial due to her illness, making her unavailable to testify in person. And also the prior opportunity for cross-examination by the defense attorney. So during that deposition, when the attorney had the opportunity to cross-examine Jane and challenge her statements, that allowed for this sworn testimony and this exception to the hearsay rule to apply in this particular situation.
All right, so the second exception, according to the statute, is in a prosecution for homicide or in a civil proceeding, a statement made by a declarant while believing that his or her death was imminent concerning the cause or circumstances of what the declarant believed to be impending death. All right, so let's imagine a situation where a patient, let's bring back Sarah, undergoes a surgery at a hospital. So during the surgery, complications arise and Sarah's condition deteriorates rapidly. So the medical team struggles to try to stabilize her, but she believes she's about to die due to the medical errors made during the surgery. So during that time, Sarah manages to speak to a nurse, let's call her Lisa, while her condition is critical. In her final moments, Sarah tells Lisa, "I can't believe they messed up the surgery so badly. I'm dying because they left a surgical instrument inside me." So the Sarah is very astute, but tragically she passes away because of the surgery, and her death is officially recorded as complications from the surgery. So later, Sarah's family files a medical malpractice lawsuit against the hospital and the surgical team alleging negligence. As part of their case, they seek to introduce Sarah's statement to Lisa about the surgical instrument being left inside her as an exception to the hearsay rule. So in this scenario, Sarah's statement to Lisa may be admissible as an exception to the hearsay rule. And the key elements to look for in this exception, in order for this exception to apply, include the declarant's belief of imminent death, which Sarah believed at the time that she was about to die due to the complications from the surgery. Next is that the statement concerning the cause of her imminent death, right? So the statement has to be about that imminent death. And here, her statement was directly concerning the reason that she believed she was about to die, which was that the surgical instrument was still left inside of her. And next, the availability of the statement, right? So Sarah here is unavailable because she passed away, so she's not going to be able to testify in court. And then also it has to be relevant to the case, right? So obviously the statement about why she believes she died is certainly relevant to the medical malpractice case and what, possibly caused her death. And the key elements to look for in this exception, in order for this exception to apply, include the declarant's belief of imminent death, which Sarah believed at the time that she was about to die due to the complications from the surgery. Next is that the statement concerning the cause of her imminent death, right? So the statement has to be about that imminent death. And here, her statement was directly concerning the reason that she believed she was about to die, which was that the surgical instrument was still left inside of her. And next, the availability of the statement, right? So Sarah here is unavailable because she passed away, so she's not going to be able to testify in court. And then also it has to be relevant to the case, right? So obviously the statement about why she believes she died is certainly relevant to the medical malpractice case and what, possibly caused her death. So under these circumstances, Sarah's statement to Lisa might be admitted as an exception to the hearsay rule to establish a potential cause for her death, which is central for the medical malpractice claim.
All right, the third exception when a declarant is unavailable, according to Georgia law, is a statement against interest. A statement against interest is a statement which a reasonable person in the declarant's position would have made only if the person believed it to be true, because when made it was so contrary to the declarant's proprietary or pecuniary interest, or it had so great a tendency to invalidate a claim by the defendant against another, or to expose the declarant to civil or criminal liability, and is supported by corroborating circumstances that clearly indicate the trustworthiness of the statement if it is offered in a criminal case as a statement that tends to expose the declarant to criminal liability. All right, so we're not criminal lawyers, we're civil, so let's imagine a civil lawsuit in which two former business partners, Alice and Bob, are in a legal dispute over the division of assets following the dissolution of their partnership. Alice claims that Bob owes her a significant amount of money as part of their separation agreement, but Bob disputes this claim. Now, during the trial, Alice's attorney wishes to execute an email or introduce an email exchange between Alice and Bob from the time the partnership dissolved. In one of the emails, Bob writes to Alice, quote, "I admit that I owe you the money as specified in the separation agreement. I'll make arrangements to pay you as soon as possible," end quote. Number one, he's a bad lawyer. But number two, in this scenario, Bob's email admitting his obligation to pay Alice falls under the statement against interest exception to the hearsay rule. So the key elements here for this exception to apply include the statement is against Bob's interest. Bob's statement in the email is against his own interest because it admits a financial obligation to Alice. And then also the availability of the statement. Bob is a party to the lawsuit, so he is available for cross-examination, making his email admissible. Now, the relevance to the case, clearly in this situation, the email is directly addressing the central issue to the civil case, which is the amount that Bob owes Alice, or whether Bob owes Alice as part of their separation agreement. So since Bob's email meets this criteria, it can be introduced as evidence in the civil case as an exception to the hearsay rule.
All right, so let's talk about exception number 4, and that's a statement concerning the declarant's own birth, adoption, marriage, divorce, legitimacy, relationship by blood, adoption or marriage, ancestry, or other similar fact or personal or family history, even though the declarant had no means of acquiring personal knowledge of the matters stated, or a statement concerning the foregoing matters and death also of another person, if the declarant was related to the other by blood, adoption, or marriage, or was so intimately associated with the other's family as to be likely to have accurate information concerning the matter declared. All right, so what does that mean? Okay, so let's imagine a case in which a person, we'll go with Sarah, is attempting to establish her eligibility for a government program that provides benefits to the descendants of military veterans, okay? So in order to qualify for the program, Sarah must prove that she is the biological child of her late father, who is a decorated veteran. So Sarah has to submit an application to the government agency overseeing the program and includes a sworn affidavit in which she declares, quote, "I am the biological child of Sam, who served in the military from 1990 to 2020. Okay? Then Sarah also has to attach a copy of her birth certificate, which lists Sam as her parent. So after reviewing Sarah's application, the government agency requests additional documentation to verify her eligibility. But unfortunately, Sarah's father has passed away several years ago, and there are no living witnesses who can testify to their relationship.
Finally, exception number 5 is, according to Georgia law, a statement offered against a party that has engaged or acquiesced in wrongdoing that was intended to and did procure the unavailability of the declarant as a witness. All right, so imagine a criminal trial in which the defendant John is charged with arson. The prosecution alleges that John intentionally set fire to a building he owned in order to collect insurance money. The key witness in the case is Sarah. Sarah's a star here,
Of course.
who was John's close friend and the only person present when the fire started. Before the trial, Sarah made a statement to her sister, Emily, revealing that she had information about John's involvement in the arson. Sarah told Emily, quote, "I saw John start the fire intentionally to claim insurance money. He asked me to provide an alibi, but I can't lie for him." However, on the eve of trial, Sarah disappears.
Beginning of a good
and
podcast.
her whereabouts are unknown. So the prosecution believes that John may have engaged or acquiesced in wrongdoing to make Sarah unavailable as a witness. In this scenario, Emily's testimony about Sarah's statement to her may be admitted as an exception to the hearsay rule. So that was a long video dealing with the hearsay rule and its exceptions in the state of Georgia. If you've stuck it out with us this far, you have a better attention span than me, because
for sure.
I've zoned out at about exception 8 in law school. But we hope that you found our code word. Just send me that email to joel@gatrialattorney.com. I'll be more than happy to put a $50 bill in an envelope to the first 3 people that send us the timestamp and what the code word is. But thanks for bearing with us. We do hope that some point of this video has been helpful to you. If it has, give us a thumbs up, hit that subscribe button, and we promise next week we will be back with some more subject matter that's slightly more entertaining.
I hope so.
Yet educational.